Greetings and welcome to Tort, Wrongful Acts, and Breach of Duty, Part 4 from American Jurisprudence. Before we start, just to remind everyone that this video is strictly for the entertainment educational purposes of this YouTube broadcast, not to be used, misconstrued, or mispurposed for anything legal, lawful, personal, private, business, tax, or otherwise. Please don't do this at home. That said, please hit the like if you're here, and let's get started. So, we left off last time with Section 53, the remedies available under tort. Tort remedies primarily restore injured parties to pre-tort positions through monetary compensation, as we see in the background. Remedies aim to restore injured person to position equivalent to pre-tort status. So the only way we can get to an equivalent position is to quantify where we were, where we need to be, and the difference to make up the proper amount for a settlement. A general characteristic: tort actions recompensed in damages. That's money. Monetary compensation is the primary method to make injured parties whole. So this is the primary method that tort prescribes, remedies. Let's get to Section 54, pleading and res judicata. Pleading alternatives and res judicata doctrine shape tort litigation and prevent relitigation. So traditional tort and prima facie tort, which we went over in the last part, may be pleaded alternatively. So you could have the bar for the prima facie tort would be only the malicious intent to harm the plaintiff as a motive, and that alone would be enough for the prima facie tort. However, if you also have more material, more evidence, things like negligence, then perhaps traditional tort would be the better way, but you could plead them both in the alternative. Res judicata applies to tort judgments and bars subsequent contract actions and vice versa. So if you had a previous judgment regarding a contract action that may bar to a tort action, and the other way around, if you had a judgment according to a tort action, it may bar a contract action later. Our supplement case: tort law recognizes a claim for damages where a bystander suffers great emotional distress after witnessing an accident or its gruesome aftermath involving death or serious injury to a close relative. So the law recognizes that claim because it wasn't just that they observed and witnessed the accident and its gruesome aftermath, but it involved the death or serious injury to a close relative, causing that great emotional distress. So whoever caused the accident caused that great emotional distress too. And that's from the Rabideau versus City of Racine, 2001, Wisconsin. And we're on to injuries to different rights, the general rule. A single wrongful act causing different injuries gives rise to only one cause of action. So that single wrongful act, even though maybe different injuries were the result of it, it only gives rise to one cause of action. So that must be, the pleading is very important in there. Single wrongful act may cause different injuries. Example given here is the person and property, different injuries, but only one cause of action arises. Recovery in one action bars another action for the same tort, even for different injuries. Example here is judgment for property damage bars a later action for personal injuries from the same mishap. Similar torts like invasion of privacy, false light, defamation from single publication, the plaintiff may cover only on one theory, but plead alternatively, as we saw. So you only get to recover one, but you may have an alternative plea. Single wrongful act results in multiple injuries. However, there will only be one cause of action because there's a single wrongful act. The cause of action comes from the act. The injuries are what are going to prescribe the damages. Now we're on to the injuries to different rights, the exception and caution. Rarely, separate actions may be brought for a person and property injuries from the same wrongful act. An exception here, judgment for injury to person property doesn't bar later action for injury to the other. So the judgment now coming in, as we saw before, the distinction here, just to be clear because it seems to contradict, but a single wrongful act causing different injuries is one cause of action. So in other words, it has to be something where there's only one cause of action. But in this case, rarely separate actions may be brought for person and property injuries from the same wrongful act. The exception is when judgment for injury to person property doesn't bar later action for injury to the other. So that's the exception there. If a judgment doesn't bar later action, but if the judgment does, then that's a different case. Of course, applies regardless of whether the first judgment was for plaintiff or defendant. So it's either side, whichever the judgment was favoring, it would have to be part of a judgment that would bar it. Rarely, the separate actions may be brought for the same wrongful act, but the caution coming here is that the judgment in the first action may preclude relitigation of identical issues in a second action. So it's a chance, it's a risk to take there. But again, if it's depending on what the goal is and how it's played out, it's a necessary exception. Now we get to 56, failure to assert claim. And happy Sunday to all you too. Greetings to you, the most beautiful buzzkill. Let's proceed. Failure to assert tort claims via set-off or counterclaim doesn't generally bar subsequent actions. So a prior judgment where the tort claim could have been asserted doesn't release the defendant. The rule applies regardless of prior action type, whether the prior action was a contract action, another tort action, or equity. But the failure to assert it doesn't generally bar subsequent actions. So the prior judgment where the tort claim could have been asserted doesn't release the defendant. However, it doesn't necessarily mean there is a valid cause of action. That has to be figured out, but it doesn't release the defendant. So that wouldn't be a counterclaim for the defendant there. Again, the exception is if the tort claim necessarily adjudicated in prior contract action. So if the prior contract lawsuit necessarily adjudicated the tort claim, then the tort claim, you wouldn't be able to file an action in that because the adjudication of the prior contract action that necessarily contained that tort claim would bar the subsequent action. So that's the exception. And we're on to section 57, concerted action, liability conditions. Here we have parties acting in concert are jointly and severally liable for resulting harm. The liability attaches when, during a tortious act in concert with another, so this is our concerted action, is in concert with another, or pursuant to common design. This is an important concept here, common design. Knowing others' conduct constitutes breach of duty. So you know the other's conduct, that constitutes a breach of duty in giving substantial assistance and encouragement. And 3, giving substantial assistance to accomplish tortious result while one's own conduct constitutes breach of duty. So again, this is where the liability attaches. Doing a tortious act in concert with another or pursuant to common design, so kind of conspiring here. 2, knowing the other's conduct constitutes a breach of duty. You know the other guy is breaking his breach of duty. And giving substantial assistance, encouragement. Yeah, go ahead, keep doing it. Encouragement. And 3, giving substantial assistance to accomplish tortious result, while one's own conduct constitutes breach of duty. In other words, one's own conduct has a duty to not give assistance to someone causing tortious results. So those are where the liability attaches. The substantial assistance, knowing the conduct and the breach of duty, and encouragement, and also, of course, doing the tortious act in concert. Joint liability creates flexibility for plaintiffs to pursue full compensation. So this here is where the concerted actions, the joint liability, comes into play to ensure full compensation for the injuries. All right, come on, let's do it. Where to go? All right, now we're on to concerted actions with joint liability and settlement effects. A plaintiff may sue jointly or severally. A settlement with one joint tortfeasor does not release the other joint tortfeasors from liability. The execution of covenant not to sue with one defendant does not release claims against other joint tortfeasor. But we're going to find out how that plays also. So a practice guide here is, if 2 persons would otherwise be liable for a harm, one of them is not relieved from liability by the fact that the other has an absolute privilege, perhaps by contract, or act, or an immunity, absolute privilege to act, or an immunity from liability to the person harmed. So 2 persons acting, one of them is not going to be relieved from liability by the fact that the other has either an absolute privilege to act, perhaps and the contract stipulates that, or has immunity from liability for whatever the reason that would be, to the person harmed. So if one person gets off because they have some kind of privilege or immunity, it does not shield the other tortfeasor. Key principle: a person who joins in committing a tort cannot escape liability by showing that another person is also liable. That a third person cooperated in the wrong is no justification for the misconduct of the defendant. Well said. And we're on to, still on section 57 here, the concerted action, and here's our supplement case. Liability extends to those who substantially assist or encourage tortious conduct. Here's our supplement case. Liability may be imposed on one who aids and abets the commission of an intentional tort if the person, A, knows the other's conduct constitutes a breach of duty and gives substantial assistance or encouragement to the other to so act, or B, gives substantial assistance to the other in accomplishing a tortious result, and the person's own conduct, separately considered, constitutes a breach of duty to the third person. So, the encouragement and assistance makes one liable. So we have, and that was from Berryman versus Merit Property Management in California, 2007. So, knowledge of the breach of duty, or substantial assistance or encouragement, and an independent breach of duty. These are where the liability extends to those who substantially assist or encourage a tortious conduct. So this is how we bring in the joint liability Here's 58, the absence of concerted action, and what we call the modern rule. Joint several liability applies even without concerted action when separate acts cause indivisible harm. Modern authority. This is what we call the modern rule. The joint and several liability exists even without voluntary, intentional concert. This applies when separate acts combine to produce a single, indivisible injury. So this is quite important here, this concept of an indivisible injury as opposed to one that can be apportioned or divided up amongst tortfeasors. This applies when there's an absence of a concerted action, but there are joint tortfeasors. It applies when the separate acts combine to produce a single indivisible injury. And from the modern rule, here are our required elements. One is the acts are concurrent in time and place. So this is an important element right here. Also that they unite to set in operation a single destructive force. And finally, the injury wouldn't occur without the concurrence. That's the acts concurrent in time and place. And of course, this all is united in operation in a single destructive force. Now we're on to the absence of concerted action, the application. The plaintiffs may choose how to pursue tortfeasors when harm is indivisible. Here's our practice guide. The injured person may, at his option or election, institute suit for the resulting damages against any one or more of the tortfeasors separately, or against any number or all of them jointly. So it's up to the injured person at his option or election to institute suit. Example here, this is a good one. Front seat passenger urging driver to disobey traffic laws may be liable to injured back seat passenger. So you have a front seat passenger urging the driver to disobey traffic laws, resulting in some type of accident, I would presume, causing injury to the back seat passenger. The back seat would be able to take tort action against that front seat passenger for that encouragement, the urging to disobey traffic laws, having knowledge of it, knowing the result of, going in the opposite lane or what have you. And we're on section 58, the absence of concerted action. And here's another supplement case, the concurrent wrongdoing theory. Concurrent wrongdoing theory supports joint and several liability. Supplement case. Under concurrent wrongdoing theory of liability in tort actions brought under New York law, when two or more tortfeasors concurrently or in concert to act concurrently or in concert to produce a single injury, they may be held jointly and severally liable. And that's in Ray methyl tertiary butyl ether, MTBE, and that's products liability litigation from Southern District of New York, 2010. Alrighty. If anyone has entered in here, I know the notifications, I didn't get one tonight, so I appreciate anyone that is in here. Let's continue on. Section 59, with the joint liability is not recognized. Here are the principles. Some jurisdictions reject joint liability when tortfeasors act independently, causing, here's a key though, distinct, apportionable injuries. Not unite for a single destructive force, not causing one single injury, but distinct, apportionable injuries. They could be apportioned out the damages. So each tortfeasor is liable only for damage caused by their own act. The joint answer doesn't prove joint liability, though. Some courts distinguish between willful torts requiring cooperation and negligence, no cooperation required. So that's some courts. This applies when there is no concert or common intent. So the conspiracy aspect isn't present. The acts are separate in time and place, so they're not necessarily concurrent. And the injuries are distinct and apportionable, not unified for one single destructive force or one single injury. So this is where the joint liability is not recognized. Yeah, definitely appreciate everyone that comes in for the live streams, and please post questions or any kind of other clarifications we can do. That always makes it interesting, and we do have Black's Law handy for any kind of digressions we need to go into definitions of the terminology here if there is some that comes across as unfamiliar. So just hit the word. On section 59, we have joint liability not recognized in the supplement case here, is that courts may apportion damages between intentional and the negligent tortfeasors. So we have intentional with a motive and the negligent that could be no motive. Supplement case here is statute permitting joint and several liability in actions requiring proof of intent did not preclude apportionment of damages for tenants' personal injuries between a negligent landlord and non-party assailant who attacked tenant. Negligence claims against landlord did not require proof of intent, and the fact that non-party tortfeasor acted intentionally did not bring claim within scope of statute. So this seems like there's a statute permitting joint and several liability in actions requiring proof of intent. Okay, did not preclude an apportionment of damages. So personal injuries, and I guess did not require proof of intent, negligence claim against the landlord. So the landlord seems like he hired a guy to go beat up his tenant, and in this case here, the tenant was able to get apportioned damages, even though I guess in a way this was somewhere where the joint liability shouldn't be recognized. Still trying to read into this a little bit deeper here. But if the statute permitting the joint and several liability in actions, there's an action requiring proof of intent. But the negligence claim did not require proof of intent. So the statute permitting the joint and several liability. Okay. Did not preclude a portion of damages. Okay, permitting. So in this case here, this way the courts may apportion damages between intentional and negligent tortfeasors. So negligence wasn't required as proof of intent. So the intentional, I guess, would be the non-party tortfeasor act, yes. And the fact that he acted with intent did not bring claim within the scope of the statute. A little confusing there, but we could read more into that. That's Chinese versus Meyer, New York, 2002. But here we have the negligent landlord, an intentional assailant. So we have negligence and intent. In this case, we are able to get the apportioned damages. For whatever reason, the statute part here gets a little bit confusing, but the basic concept is that joint liability is not always recognized. So with the joint liability, there would be no apportionment because there would be a single destructive force. But here, I guess the blurred lines here with the negligent landlord, intentional assailant, and the plaintiff was able to get apportioned damages. Only in New York. All right, we're on to section 60. Hey, greetings to Shaggy Hippie. Much love to you too, and hit the like button, people, for sure. And join the membership too. Got some new levels there, and we're planning some members-only live streams, as recommended by our generous corporate sponsors. And we definitely want to reciprocate their generosity by encouraging their algorithm. So let's continue. Non-participants. liability conditions A through E. For harm resulting to a third person from the tortious conduct of another, one is subject to liability if he, A, orders or induces the conduct, if he knows or should know of circumstances that would make the conduct tortious if it were his own. So orders it to someone knowing that if it was his own conduct, it would be wrong. Conducts an activity with the aid of the other and is negligent in employing him. So you have your helper help you do something tortious. C, permits the other to act upon his premises or with his instrumentalities, knowing or having reason to know that the other is acting or will act tortiously. This is really bad. This is harm resulting to a third person from the tortious conduct of another, and one is subject to the liability of this. Controls or has a duty to use care to control the conduct of the other, who is likely to do harm if not controlled, and fails to exercise care in the control. Keep your dog on a leash, I think this means. And E, has a duty to provide protection for or have care used for the protection of third persons or their property, and confides the performance of the duty to the other, who causes or fails to avert the harm by failing to perform the duty. I told you to clean up the water spots on the floor before someone slips. So yeah, this is where you see the non-participant's liability. You can delegate authority, but if it's your duty, you're responsible. All right, we're on to section 60 and the non-participant's definition in a supplement case. Liability attaches to those who substantially assist or encourage tortious conduct, even if they don't directly commit the act. The participant definition. In other words, to be a participant in a tortious act, one need not be the person who actually commits the act. Liability extends beyond direct actors to those who enable tortious conduct. So those who enable, the enablers. The enablers get the liability extended. Supplement case. The question of whether a defendant has substantially assisted or encouraged another person in his tortious conduct. So was this substantial, the assistance or encouragement, such that in concert liability will attach to the defendant, is a question for the jury. Restatement, second of torts. So there you go. That's the jury's out on that. If you want to know the answer to that question, it needs to be before a jury. And this is why you'll see as we continue on here, common enterprise principles. The parties in unlawful common enterprise, that's a nice euphemism, are jointly liable for connected wrongful acts. Joint liability for wrongful acts in furtherance of unlawful enterprise applies even if the damage, this should be a non-equal sign. I don't know why it's that. So applies even if damage is not foreseen, act not contemplated, or only one participant cause the injury. So here's our illustration. Multiple persons firing the gun wrongfully. Each are liable for the injury, even if you can't identify the actual shooter. So in a firing squad, they're all each liable for that single injury. The alternative rule, when acting lawfully together for common lawful purpose, one's not liable for unlawful act of another without concurrence. So I guess if it's a lawful firing squad, then in that case, only the person that actually did shoot would be the one liable. But if you can't identify the shooter, then I guess that's how they all get off. There you go. And on to the Common Enterprise Supplement case, the Uniform Contribution Among Tortfeasors Act. Uniform Contribution Among Tortfeasors Act. is designed to judicially control damage distribution. So, the reason for this act you'll see here in the supplement case. The intent of the Uniform Contribution Among Tortfeasors Act was to interject judicial control over the distribution of damages in tort claims in which there is more than one tortfeasor. That comes from Am Jur versus Baptist Healthcare of Oklahoma, and that's Oklahoma, 2001. So we can see from the Uniform Contribution Among Tortfeasors Act to allow judicial oversight prescribing the distribution of damages in tort claims. There's going to be an amount that needs to be compensated to the plaintiff, but the way that's distributed amongst the tortfeasors is under judicial oversight, and that is supposedly to ensure a fair damage distribution. And this only applies when there's multiple tortfeasors. So if the judge can find that one tortfeasor is causing more of the damages, then perhaps more of the damages payment would be prescribed to that tortfeasor. But that's up to the discretion there. So that's where the Uniform Contribution Among Tortfeasors Act comes into play. And we're on to the defenses now. Section 62, privileges and satisfaction. So defenses and settlements affect joint tortfeasor's liability. One tortfeasor's personal privilege, as we read before, example given here, immunity, doesn't shield other tortfeasors from liability. He did it. No. An injured party can receive only one full satisfaction for damages. Full satisfaction, bars further proceedings. A release of one joint tortfeasor doesn't automatically release others. The plaintiff's intent determines the effect. Nice. So you have personal privilege. It doesn't shield the others from liability. So the personal privilege may be, in a contract stipulation that you can't sue. That personal privilege there, or can't be sued by that party, by the plaintiff, because there was a contractual stipulation. I don't know. There could be a lot of conditions, but that won't shield the others from liability. Once a plaintiff has received a full satisfaction, is made whole through compensation, it bars further proceedings. And the release effects are determined by the plaintiff's intent. The plaintiff decides who gets released and the effects of that. So let's continue. And we're on to the defenses, the covenant effects. So the covenants not to sue reduce awards against the remaining tortfeasors. So if they're paying off $1 million and one of the say you have several tortfeasors and one of them makes a deal with you not to sue, and they'll pay you a certain amount, say $100,000, then if there's $1 million due, it's only going to be $900,000. It's going to reduce the award against the remaining tortfeasors. Then they'll have to divvy that up. So by letting one person off the hook, part of that money that's paid in doing such comes out of the satisfaction, the full amount for satisfaction. That'll be put into that and towards that, so that the remaining tortfeasors only have to make up that difference. When a covenant not to sue is executed with one tortfeasor, awards against others are reduced by the amount received. The plaintiff's intent determines whether a release of one tortfeasor affects the other's liability. So it could be that the plaintiff says, well, if one of them pays, then everyone gets off, and that could be part of the terms of the covenant. It's up to the plaintiff's intent. The settlement with one tortfeasor always will result in reduced awards against the others. Key point. And here's our supplement case. The policy of the Uniform Contribution Among Tortfeasors Act is to encourage rather than discourage settlements. So that's the policy, is to encourage rather than discourage settlements. That's from the Calise versus Hidden Valley Condominium Association in Rhode Island, 2001. As we see here, the policy of the Uniform Contribution Among Tortfeasors Act is to encourage rather than discourage settlements, as we saw before in the previous slide here. Let's see here. I think it was this one here. Well, go back a little far here. Either way, the point is that there is a policy here. See this one here. All right, never mind. We'll edit that part out. The Uniform Contribution Among Tortfeasors Act is there to encourage rather than discourage. The question for the jury. So whenever you have joint liability, it's a question for the jury whether that's the situation or not. And let's see, what was that exact question there? And that was one of our highlights here too. So that one we should definitely, the restatement of the torts. Question of whether a defendant has substantially assisted or encouraged another person in his tortious conduct, or liability here, such that in concert liability will attach to the defendant, is a question for the jury. Therefore, what we have here is the Uniform Contribution of Tortfeasors Act, the Uniform Contribution Among Tortfeasors Act. They're to encourage rather than discourage the settlements, because by having settlements, you don't have to go through the pain of the jury. So again, settlement with one tortfeasor means reduced award against the others. Therefore, it makes sense to come up with full settlements usually, because as it goes on, there's less return for the litigation. So you can see how that policy works. All right, we're on to 63, the separate actions. Actions against some joint tortfeasors don't generally bar claims against others. So commencing proceedings against some tortfeasors doesn't generally preclude actions against remaining tortfeasors. Important to know that generally here. So multiple simultaneous actions against jointly severally liable tortfeasors are permitted. So they're jointly multiple simultaneous actions. So multiple joint. These are joint tortfeasors and multiple joint tortfeasors. Separate actions are permitted, and claims against others are preserved. The exception is if commencement of first action constitutes waiver of tort as to others not party to it. So I guess that would be if there's a waiver involved. All right, so we're on to the conclusion for the joint liability. Part one here was the concerted action, that parties acting in concert are jointly and severally liable. The liability attaches when acting together, knowing breach, or giving substantial assistance or encouragement. Settlements with one tortfeasor preserve liability of the others, though, so it's not going to shield them. In absence of concerted action, now we have joint and several liability applies even without the concerted action when separate actions cause indivisible harm. Again, that single destructive force required. Concurrent acts, single destructive force, and the injury wouldn't occur without that concurrence. So they're not in concert, but in concurrence. Plaintiffs may choose how to pursue tortfeasors when harm is indivisible. So when there's just that single injury, then the plaintiffs may choose how to pursue the tortfeasors. Core principle here is joint liability principles ensure victims can recover full damages regardless of how tortfeasors acted, whether in concert or independently. So the flexibility for the plaintiff is what that's there for. Now we get on to the other part of the joint liability conclusion here with the limited liability. Some jurisdictions reject joint liability when tortfeasors act independently. This applies when there's no common intent, acts are separate in time and place, so there's a lack of that concurrence here already, and the injuries are distinct and apportionable, so they're not indivisible, they're apportionable. And they're not a single unified destructive force, they're distinct. So you can already see why the joint liability would be limited or not applied. Each tortfeasor in this case would be liable only for the damage caused by their own act, and this is by jurisdiction. Then there's non-participants and common enterprise. Liability extends to those who instigate, aid, or fail to control tortious conduct. Parties in lawful common enterprise are jointly liable for connected wrongful acts. So the unlawful common enterprise, otherwise it was a crime. So parties in unlawful common enterprise are jointly liable for connected wrongful acts. They're all making profit from it. Uniform Contribution Among Tortfeasors Act promotes settlements. So again, this is all about the compensation, the monetary compensation. The less money they spend litigating, the more money is there to make the plaintiff whole. And I think that's part of the policy of the Uniform Contribution Among Tortfeasors Act, is that when there's all these different litigants and there's so much flexibility in the way the plaintiff can pursue, that the settlements are the most efficient way of effecting justice. The strategic considerations here: the joint liability principles balance victim compensation with equitable allocation of responsibility, ensuring injured parties recover while holding all responsible parties accountable. And that takes us to the end of Tort, Wrongful Actions, and Breach of Duty, Part 4, where we went over the remedies for tort and also the joint liability aspects, both in concert and not in concert, the limitations and the exceptions. So I hope you all learned a little bit about tort. We're going to finish up with Part 5 coming next, and that will complete the American jurisprudence portion on tort. So, yeah, this has been a pretty good presentation. I thought it was only going to be 2 parts, but it was so extensive I had to extend it into 5. So, thank you all for being here. Salute to you all for going through and sticking with learning this, which is a very important topic for all of us here as we exercise between the public and the private, and where injuries are just, it's inevitable, if not eventual. So with that being said, I thank you all for coming, and I hope to see you all on the next one. Peace out.